What's going on, everybody? I wanted to talk about something. And the reason why I'm talking about this is because I've already explained this in videos, but I want people to understand. And I have to keep in mind that when people see a video of mine, they're not always, you know, seeing all of the videos. But I've explained this in my why you don't need a Form 56 video because everybody tells you you need a Form 56 like the IRS is God or the IRS runs the courts or the banks or the finance. The IRS doesn't run shit. I'm gonna be honest with you. And this is from a person that shut down a whole courthouse with using the IRS. The IRS does not run shit. The IRS has to go to the FBI to even enforce their codes because the IRS doesn't carry guns. So we're gonna tell. I told you guys already that you don't need a Form 56. You can just appoint a fiduciary by letter. So sometimes I think people get locked into IRS forms because they listen to other people, and a lot of these people really don't even know what they're talking about. So when I'm saying that, I'm not saying it in a disrespectful manner because I don't know everything myself. But we need to understand what a fiduciary duty is or a fiduciary duty acknowledgement is. So when a company receives your loan documents or they receive your uh anything as a fiduciary, right? That just means first you have to know what a fiduciary is. Okay, so let's get into what a fiduciary is. So, a fiduciary involving trust, especially with regarding to a relationship between a trustee and a beneficiary. So, in all of your agreements, what happens is they assume the role as a beneficiary because you don't know how to express that you're a beneficiary and dictate how the funds are supposed to be dispersed on the agreement. Okay. So you don't need a Form 56. And I want people to understand this. Stop listening to people. Start reading these forms. Start reading the instructions because it will tell you stuff. It's just like I did a video and I did a video talking about subject matter jurisdiction, and somebody's like, "Well, show me one case where somebody's won off of subject matter jurisdiction." I was like, "You don't even know what subject matter jurisdiction is, so you don't even understand why what subject matter jurisdiction is." But I'm not here to condemn. I'm here to educate. So look, a fiduciary acknowledgement. What is it, or what it is? A fiduciary acknowledgement is a simple recognition by a party that they owe fiduciary duties like loyalty, care, good faith, disclosure to someone else regarding certain property rights, interests, or authority. So whenever the bank gets your contract, they're instantly a fiduciary, but you are too. That's why I told you everybody's like, oh, you got to go to the indentured trustee. Oh, you got to do this stuff. No, you don't. You don't have to do none of that stuff. But that's people's understanding, so I'm just gonna let it be. So look, it can be voluntary, signed agreement, contract, or declaration, or implied by conduct, by law, or by relationship, like trustee to beneficiary, agent to principal, guardian to ward, attorney to client, etc. So you have to understand when a company has a contract and you're named in that contract, what happens is the company acts as the beneficiary because you don't know what to do. So I had a call, and I'm not going to release this information that I did a consultation, and we got really deep where I was showing them how, like, certain ways to attack child support that people don't even know to attack it. But we were talking about certain things, and there's a lot of stuff that people really, the public just does not know when it comes to creating agency agreements or etc. And a lot of this I have in some of my videos, that are available. So look, in commercial, legal, and trust relationship, acknowledging fiduciary duty sets the foundation for accountability. They can't just act in their own interest anymore. Obligation. They must act for your benefit, not theirs. Liability. If they breach their duties, you have remedies. So when you get in a contract, it seems as it's a unilateral contract, but it's only because they're holding one side of the ledger, as I told you before. So you can create an agreement or you can express who is obligated as the payee or who is the payee or the true payee in the agreement, and who is the payer. Okay, they're not like when you're in these credit contracts. The only reason they're just taking your money because they're taking your money and investing it. Okay, look. What about an IRS Form 56? A Form 56 notice concerning fiduciary relationship is a tax specific notification to the IRS, not a requirement for a fiduciary relationship to exist. Okay? It's not a requirement. I've expressed this to you guys. Okay? The purpose of a Form 56 tells the IRS that a fiduciary, trust, executor, or grand guardian representative, it is taking control of someone else's tax matters. That's it. So just because you get with the bank or the financial institution, you send them a Form 56, they don't have to file taxes on behalf of you because you don't have an agreement that says that they do. That's why I keep telling people read the Form 56, read the instructions, and it'll tell you what to do. If the person does not sign the Form 56, your Form 56 is nothing but worthless paper. Alerts the IRS who to communicate with about a certain taxpayer's account. Now, I know how to get past them not signing it and get it to the IRS, but I'm not even going to explain that on here and make them liable for the taxes. So, look, important Form 56 is informational, not constitutive. Okay. It doesn't create the fiduciary relationship. I keep telling y'all this, man. Sometimes, here's what I need some of y'all to do, and I'm going to explain this. You need to do your own research. I think what it is I think what people try to do is they try to get remedies so fast they don't try to understand the simplistic manners of things. You have to understand it. Stop being desperate for remedy. The remedy will come once you understand it. Look, it notifies the IRS that one exists for tax purposes. Okay. So it's just telling you that the relationship exists for tax purposes. It doesn't do anything. I don't know why people keep telling you can win a court case with a Form 56. What? Now I know there are ways to use it to where you can win a court case, but there's that I'm not going in there. I got a lot of fire court stuff that's going, and that's most of that's going on my 401 class. That the price is going to go up on the 401 class because I'm going to end up showing people how to get rid of warrants from the comfort of your couch, not to go into court anymore. So look, a fiduciary relationship can exist without a Form 56. I keep telling people this, even though I've had people in my comment section tell me, "Oh, you gotta give them a Form 56 to win in court." People act like I ain't been in court before. They act like I ain't tried all this stuff before. You only need to file a Form 56 if you want the IRS to recognize you as the official point of contact for another taxpayer's account. All right. So I'm doing this to let you guys understand that a Form 56 is not mandatory. Your court cases are not taxable. When I did a video talking about a 1099 OID, I'm talking about after the court case is disposed of. When the court case is disposed of, that's when it becomes taxable. It's not taxable while you're going through a court case. So a lot of y'all need to stop trying to go to these courts with 1099 Cs and OIDs, etc. The court case has not been disposed of, so it's not a taxable event. It's not a taxable event till it's disposed of. And even when it's disposed of, it's not fully a taxable event because you can always go back and clear that. And I got some fire for clearing up past judgments and etc., criminal records and all that. It's coming, and I'm bringing it. And with that being said, I'm out. Have a good one.